Let's start with enforcement of certain foreign awards. So till now we have discussed domestic award. Now we are starting with the foreign awards. As the heading itself says, enforcement of certain foreign awards. It means the word certain means that each and every foreign award is not enforceable in India. It's only the some awards made in foreign countries which are enforceable in India. So when we go ahead with the details of the chapter from the exam viewpoint, we discussed what is a foreign award. Is international commercial arbitration same as in the case of foreign award? No. Why? Because in arbitration, there is a word seat of arbitration, which means the place, the country of which arbitration law is being followed while conducting the arbitral proceedings and giving the award. So it's the seat of arbitration which decides whether a particular award is a domestic award or it is a foreign award. Let's discuss the various situations that if both the parties are Indian parties in the arbitration agreement, it is called arbitration other than international commercial arbitration. And if they are agreeing to resolve their dispute through the Arbitration and Conciliation Act 1996, it will be called as a domestic award. If one party is an Indian party and other party is a foreign party, it will be called international commercial arbitration. If both the parties are agreed and they are following the Arbitration and Conciliation Act 1996 for the purpose of arbitration, resolving the dispute through arbitration, the award given is called domestic award. While in the same case, one is Indian and other is a foreign party, but they are following the law of foreign country for resolving their dispute through arbitration, and that will be called as foreign award. Similar is the case if both the parties are Indian parties, but they are following the law of a foreign country for resolving the dispute through arbitration, it is called foreign award. If both the parties are foreign parties, then one thing, it is an international commercial arbitration, because international commercial arbitration definition requires one party, at least one party, to be a foreign party. And if both the parties are agreeing upon following the Arbitration and Conciliation Act 1996, then the award given will be the domestic award. If both the parties are foreign, now think of what type of arbitration will it be, and they are agreeing to follow the arbitration law of foreign country, then the award given will be of that type. Then if both the parties are foreign, it is an international commercial arbitration, and if they are following the law of foreign country, then it is a foreign award. So now whether a particular award is a domestic award or is a foreign award depends upon which particular law the parties have agreed to follow. If Arbitration and Conciliation Act 1996, that is the arbitration law of India, then domestic award, otherwise it will be a foreign award. So now, can every foreign award be enforced in India? No. As we discussed earlier, certain foreign awards. Which foreign awards can be enforced in India? Which satisfies two conditions. They are made according to the law of a foreign country, which is signatory of either the Geneva Convention or New York Convention. Second condition is, if one of such territories as the central government being satisfied that reciprocal procedures have been made by notification in the official gazette, declared to be the territories to which the said convention applies, means that the award is made following the law of a foreign country, which is signatory of either Geneva Convention or New York Convention, where the foreign countries have agreed to extend the facility of enforcement of the awards made in each other countries. Plus, the countries are actually allowing the domestic award made in accordance with the Arbitration and Conciliation 1996 to be enforceable there Then the central government will on the reciprocal provision basis will declare that the territories are the countries for which the said convention is applying, and the award made in those countries will be enforceable in India. If both the things are satisfied, only then the foreign award can be enforced. Now, what are the grounds for refusal of the enforcement of foreign award? Enforcement of a foreign award may be refused at the request of the party against whom it is invoked, only if that party furnishes to the court proof that we read in section 34 for the challenging and setting aside a domestic award. Just a quick recap of it is, if we have a look at section 34, it was saying that for setting aside or challenging an arbitral award, the grounds could be the party is under some incapacity, or the arbitration agreement is not valid, or a proper notice of appointment of arbitrator or arbitral proceeding is not given to the party, or the award does not deal with the dispute falling within the purview of arbitration, or the composition of the arbitral tribunal or procedure is not in accordance with the agreement of the parties. Each and every each and every dispute cannot be settled by arbitration. Most of the civil or quasi-civil nature disputes can be settled, but criminal offences cannot be settled in India through arbitration. Even some civil matters like matrimonial matters, industrial disputes and revenue matters, testamentary matters under Succession Act or Competition Acts, they cannot be decided through arbitration. That's why the court is particularly setting aside the award on these particular grounds. Now, if we look at this, the same conditions are applicable as was in section 34 plus one condition more. We know that award once given can be challenged in India within 3 days. Similar would be the provision in the other countries. So unless and until the period of challenging the award has been expired, we say that the award is not binding on the parties. And thus, till the time period of appeal of in the foreign country or setting the setting aside of the foreign award in foreign country is not expired, the enforcement of foreign award may be refused by the courts in India. Even if the award has been set aside or suspended by a competent authority of the country in which or under the law of which that award was made, then the same may be refused to be enforced by Indian courts. But if the application for setting aside or suspension of the award has been made to a competent authority and that has not been finally decided, in that case, the court in India may adjourn the decision on the enforcement of the award, and simultaneously it may ask the other party to give the suitable security. Enforcement of arbitral award may also be refused on the same grounds as was in domestic award, that the subject matter of the difference is not capable of settlement by arbitration under the law of India, or the enforcement of the award would be contrary to the public policy of India. What is the meaning of contrary to the public policy of India? The same one. Making of the award was induced or effected by fraud or corruption, or it was in violation of section 75 or section 81, that is dealing with your conciliation part, that conciliation proceedings are confidential and they cannot be used as an evidence in any arbitral or judicial proceedings. It is in contravention with the fundamental policy of Indian law. Same, if it is contravening the basic objects or the preamble of a particular statute enacted in India, then the same will be considered to be in conflict with the public policy of India. If it is in conflict with the most basic notions of morality or justice that is sitting upon the mind of the judiciary, that if such kind of award would be enforced in India, it would affect our moral values or it would be an injustice, then they can refuse to enforce the foreign award. The test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review of the merits of the dispute, because that has been resolved and the award has been given. So the court cannot go into the merits of the dispute again. It is only on the face when going through it, if it appears that it is contradicting the preamble of a particular Indian statute or the notions of morality or justice, then it will be assumed to be, it can be refused to be enforced in India. The only difference between the domestic award and refusal and the only difference between the challenging of the or the setting aside of a domestic award and refusing to enforce the foreign award in India is ground of patent illegality. We have read that in the case of domestic award, they can be set aside on the ground of patent illegality. On the face, it is appearing that they are illegal. They are contrary to the provisions of the law in India. Then the domestic award can be set aside. But the same ground of patent illegality is not applicable for refusing the enforcement of foreign award in India. The one MCQ that on which particular ground enforcement of foreign award cannot be refused, it is a ground of patent illegality. The other particular difference is, we know that the arbitration award, just like the conciliation made in India, are the confidential proceedings, and whatever has happened in those proceedings or whatever is the award, that cannot be used. Once it is binding, but it cannot be used as a defense, set off, or otherwise in any legal proceedings in India. But the same is not the case with the foreign award. Foreign award, once it is binding, means the period of challenging the award has expired, and according to the law of the foreign country where it is made, then we say it is a binding. And once it is binding, it can be used as a defense, set off, or otherwise in any legal proceedings in India. This is what we have to cover up for the purpose of foreign award for exam.